What if your refugee claim was rejected? You can have a refugee appeal. Filing a refugee appeal or responding to a minister's appeal. If you disagree with a negative refugee decision and want to appeal, you can appeal to the RAD under specific conditions. If you were granted refugee protection by the RPD and the minister is appealing that decision, you have the right to respond to the appeal and to file documents. You have to file an appeal. To launch an appeal, you must file a notice of appeal to the RAD, not later than 15 days after the day on which you receive the written reasons for the RPD decisions. You must provide 3 copies, 1 copy if submitted electronically, of your notice of appeal to the RAD registry in the regional office that sent you your RPD decision. You can deliver, mail, or fax your notice of appeal to the IRB regional office that sent the original refugee decision. What are the time limits for an appeal? The following time limits apply to your appeal. No more than 15 days after the day on which you receive the written reasons for the RPD decisions, you must file your notice of appeal. No more than 45 days after the day on which you receive the written reasons for the RPD decisions, you must file your appellant's record. Unless a hearing is ordered, the RAD will wait 15 days before making a decision on your appeal. The minister may decide to intervene and submit documentary evidence at any time before the RAD makes a final decision on the appeal. If the ministers decide to intervene and to provide submission or evidence to you, the RAD will wait 15 days for you to reply to the minister and the RAD. Once you have applied to the minister and the RAD, or if 15 days have passed and you have not replied, the RAD will make a decision on your appeal. What happens if you miss a time limit? If you miss the time limit to file the notice of appeal or the appellant's record and you still want to continue with the appeal, you must file an application for an extension time. The application for an extension of time must follow Rule 6, Application for Extension of Time to File or Perfect, and Rule 37, How to make an application of the RAD rules. You must provide 3 copies of your notice of appeal or 1 copy only if submitted electronically with your application. You must also provide an affidavit or solemn declaration that explains why you missed the time limits. Next, completing your appeal. Once you have filed your notice of appeal, you must complete perfect the process by submitting certain documents and information. You must complete your appeal by providing your appellant's record to the Refugee Appeal Division no later than 45 days after the day on which you received the written notice for the Refugee Protection Division or RPD decision. You must provide 2 copies of your appellant's record or any 1 copy of submitted electronically to the RAD registry in the regional office that sent you your RPD decision. The process. The RAD generally makes its decision without a hearing on the basis of the submission and the evidence provided by the parties, you and the minister if the minister intervenes. In certain circumstances, the RAD may allow you to present new evidence that the RPD did not have when it made its decision. If the RAD accepts your new evidence, it will consider the evidence in its review of your appeal. It may also order an oral hearing to consider this new evidence. If so, you and the minister will receive a notice to appear for a hearing. What if the minister is opposing your appeal? What can you do? If the minister decides to oppose your appeal, you will receive a notice of intervention along with any documents the minister is providing as evidence. The minister may also give you and the RAD an intervention record that includes documents like the ones listed in the appellant's record. The minister can provide documents at any time before the RAD makes a decision on your appeal. You have the right to reply to the minister's documents. You will be given 15 days to reply to them. There's always a guide on how to reply to the minister's document. Number 1, all of the part of the transcript of the RPD hearing. Number 2, any additional documentary evidence. Number 3, legal authorities. Number 4, a memorandum. All of the documents in your reply must be typed, not written by hand, in 12-point of larger font on letter-size paper, so attention to detail. And 8.5 inches by 11 inches of the paper. All photocopies should be clear and made on letter-size paper. You must provide a copy of your reply to the minister at the address shown in the notice of intervention, and then provide the reply to the RAD along with proof that you gave a copy to the minister. Your reply must be received by the RAD no later than 15 days after the day on which you received the minister's documents. The minister's address is in Immigration, Refugee, and Citizenship Canada, Reviews and Intervention Office, 25 St. Clair Avenue East, Suite 200, Toronto, Ontario, M4T1M2, and the fax number 416-952-2420. Completing the appellant's record. The RAD appellant's record form is the document in which the appellant presents his appeal to the RAD. We strongly encourage appellants to use it in order to present the best possible appeal to the RAD. If you choose not to use the appellant's record form, then you must complete your appellant's record according to the instruction of their preparing the appellant's record. They always have an instruction, so please follow that. Refugee appeals, receiving and acting on a decision. When a decision is rendered on your refugee appeal, the Refugee Appeal Division will send you a written notice of decision, along with an explanation of the reason for the decision. The RAD also sends a copy to IRCC as well as the CBSA. 3 outcomes can result from your appeal to the RAD. 1. Appeal is allowed. RPD decision is set aside. Appeal is rejected. RPD decision is confirmed. And number 3, refer or send the case back to the RPD and order a new hearing, giving the RPD the directions that it considers appropriate. If your appeal is accepted, IRCC or the CBSA may seek leave and judicial review at the Federal Court of Canada, but must do so within 15 days. If this occurs, you will be notified. If your appeal is rejected, you may wish to seek leave and judicial review at the Federal Court of Canada. If the RAD decides to refer your case back to the RPD and order a new hearing, giving the RPD the direction that it considers appropriate, the RPD will inform you of your next step, including when a hearing is scheduled.